4 keys to a killer cross-examination coming up right after this.
Yes.
Hey everyone, welcome back to the Mr. Small Claims Court YouTube channel. Always grateful to have you. A special welcome to our new subscribers. The channel's still very much in its infancy as I record this in November 2024, but our subscribership has been doubling, so I'm very excited about that, and I thank you for subscribing. If you haven't subscribed yet and just happened to land on this channel, maybe you've been looking for Small Claims Court help and wanted to learn a bit more about me and my credentials, you can see more about me in a video on the homepage of the Mr. Small Claims Court YouTube channel. And then I welcome you to join the growing list of subscribers. It takes a second to hit that subscriber button as well as the notification bell, then you won't miss a future video. The goal of this channel is to help you win in small claims court. And of course, it helps me to continue to produce videos just like this to help you win. When you do subscribe, of course, to also like, share the video with anybody who you think can really get some help from these videos. So without further ado, today's video, I'm going to talk about how to effectively cross-examine a witness at the small claims court trial. Now, this may sound somewhat hyperbolic, but I really believe this may be one of the most important videos that I do because many small claims court trials can be won or lost in the cross-examination. Now, what is a cross-examination? Essentially, what happens in the average trial, the usual disclaimer that small claims courts around the world may be different depending on your jurisdiction. It's hard to be precise when I've got a worldwide audience here on YouTube, but for the most part, in most small claims courts, both sides will have a chance to present their case. And the way they do that is by presenting their evidence, which could be by way of documents, text messages, emails, photographs, etc., as well as their testimony, both of themselves. So the plaintiff, the one who's suing, can get up and give his side of the story, and the defendant can get up and give her side of the story. And both of them, in almost all small claims courts, have a chance to also call up witnesses who will testify as to what transpired if they have direct knowledge of the events in dispute. In any event, it doesn't matter if there's a situation where it's a witness or it's the plaintiff or defendant himself or herself. Either way, in almost all small claims courts, you have a chance to ask questions of the other side when they're under oath giving testimony. You have a chance to examine them, to ask them questions, and that's called, in almost all small claims court, a cross-examination. And if you've watched my earlier videos, part of what you're trying to do at the trial is not only to present your case and put your best foot forward, but of course to refute the defendant's side of the story, assuming you're the plaintiff in this case. Okay, this obviously applies equally to defendants or plaintiffs. Right now, I've been doing videos from the perspective of the plaintiff. That's the vast majority of people who will be coming to these videos, but there will be future videos from a defendant's perspective. And anyways, if you are a defendant watching this, you can certainly glean from what I'm sharing here in these videos to apply to your case. That said, both sides will have a chance to ask one another questions, not only of the parties themselves, their witnesses too, if there are any, to try and elicit what it is that they need in order to disprove the other side. So let's take our example case we've been using. And once again, if I interchange names, forgive me. I've been trying to be consistent, but I do have other things going on in my life at the same time as doing these videos. So it's not so easy to always keep in mind the names I've been using in the sample cases. Obviously, that's in the earlier videos. But let's say we're talking about a case of John's Landscaping. Okay, you're John for the purpose of this illustration. And the defendant, the person that you've named, the person who you're suing, is Jim Smith. And John's Landscaping did work for Jim Smith, landscaping work that is, and Jim Smith is refusing to pay John for the landscaping work that was done. Now, just to add a few facts, because what I'm going to do is I'm going to give you some sample types of questions you can ask under that cross-examination. I've got my trusty whiteboard here, which I'll get into in a minute, but just trying to set the stage. So John's Landscaping has sued Jim Smith. And what's happened is that Jim Smith is claiming a whole bunch of things. Okay, number one, Jim Smith is saying that he never agreed to the price that John is claiming in the lawsuit. So there was a contract for a certain amount, but then what happened was, as the business relationship continued, Jim Smith asked for some change orders. He asked for some changes to the landscaping work that John was to do under the contract. And John is arguing that whereas the contract started with a $5,000 fee, it ended up being $10,000 because Jim wanted all sorts of extra materials and he wanted extra work done. Initially, he only asked for planting flowers in a rock garden. Then he wanted some work on his deck. That was done. And so John sued Jim. John, sued Jim for $10,000. And Jim's claiming, no, there was never any contract for $10,000. At most, it was $5,000. He's denying the entire $5,000 anyways, but he certainly says, I never agreed to any change orders. Jim is also saying in his defense that the materials that John used were shoddy. They were not good materials that were not good for his yard. As well, Jim, the defendant, is claiming that the work that John did, the work that John, did was shoddy. It was not workmanlike, and I don't want to pay you for any of it. I had to redo the work that you were supposed to have done for me, and therefore I don't have to pay you anything. And it's important to note that all these things that Jim is saying, for the purpose of our illustration of what an effective cross-examination is, Jim has testified to all this. Okay, so John, as the plaintiff, got up and gave his case. I've talked about in earlier videos how to do that, how to ask questions of your own witnesses. That could be you yourself as the plaintiff or witnesses who are testifying for you. So see the video right before this one. I think it's video 9 and maybe 8. It's either 8 or 9, where I have a whole video about how to ask questions of your own witnesses. So you've given the testimony for your own case, and Jim, in response, has given evidence where he claims all these things that I just said before, that he didn't agree on the price, the work was bad, etc. So now you, John, are getting up and you have a chance to discredit everything that the defendant said by asking him questions such that the answers that the defendant gives, that Jim Smith gives, will actually end up helping your case and not Jim's. And by the way, as you'll soon see, you don't necessarily need an answer. With an effective question, a lot of times that's enough to impress upon the judge that you have a good refutation of everything that the defendant is saying. I'll explain more as we go on, but that's the setup here, okay? Now, I've got my trusty whiteboard, old school. For those who have subscribed and have seen past videos will know that this is something that I've been relying upon. I'm a bit of a dinosaur. I've got my trusty whiteboard, and here we've got the 4 keys to killer cross-examination. I've already joked about my handwriting. Maybe I should have been a doctor. Instead, I'm a retired small claims court lawyer, but that's what it says here. 4 keys to killer cross-examination. And I've started with the 4 keys at the top, and then I'm going to go down to use examples of how this works in action. By the way, before I forget, something that I should mention as well is that the only way this can really be effective for you, that you can have an effective cross-examination, is if you're paying close attention to everything that the defendant is saying. A lot of times plaintiffs are so in their own case, in their own heads, they're so angry and emotional at everything that the defendant's saying, they're not paying attention and focusing on what the defendant's saying. The only way that you can really have an effective cross-examination is if you focused on what the defendant says, so that you can then go and refute everything that the defendant said in his testimony. So I did mention this in the early video, how you have to pay close attention to what the defendant's saying. And as you'll see now, that's all the more crucial when you're asking questions of the defendant, so that you know what to ask based on everything that the defendant said. Of course, even if you haven't paid that close attention, or you missed a few minutes here or there, yes, maybe you already know what the defendant's going to say based on past history. But obviously, by hearing what the defendant said today in the courtroom in front of the judge, you'll have all that much more of an effective cross-examination. So the first key that I've stated here in terms of an effective cross-examination is warm-up. Okay, what do I mean by warm-up? Well, before you start attacking the premises that the defendant has put forward in the court, you want to kind of get the defendant somewhat comfortable with answering your questions. Because if the defendant is on guard the minute that you get up, then the defendant may not give you the responses that you're trying to elicit. Again, as we'll soon see, you don't always necessarily need a response from the defendant, but oftentimes you do want to get some good admissions from the defendant. And the best way to start off your cross-examination is to start off with a good warm-up. So warm-up could be, so Mr. Smith, you're the defendant in this action, right? It could be a very simple type of questioning. You're not trying to prove refute the defendant's case right off the bat. You're just trying to warm up the defendant so that he gets used to answering your questions. And then as you've got him warmed up, you start laying your trap, if you will. Okay, but for the beginning, you want to warm up. So you can ask, so Mr. Smith, you're the defendant here? Yes, I am. And you live at 55 Cucumber Lane. Is that correct? Yes. And you've got a yard there. Is that right? Yes, I do. And the yard is about whatever square feet. Yes, it is. So very innocuous questions. You don't have to go on and on and on. In fact, you have to be careful not to test the judge's patience. The judge may say, can you get to the point already? Again, different small claims courts have different time frames that they allow for your questioning. Some judges will be more patient than others. So you don't have to go on, but you definitely want to ask some questions just to warm up the defendant. And that ties into my second key, which is, this is not the movies. That's what I wrote here. This is not the movies. What do I mean by this is not the movies? You're not here to yell and scream. Okay, don't fancy yourself as Tom Cruise cross-examining Jack Nicholson in A Few Good Men.
You want answers. I want the truth.
Okay, you can be and should be perfectly polite and civil, as much as that may be very difficult. I understand relationships may be very toxic when it comes to small claims court. That's why you're there in the first place. If nothing more, put on a show. Okay, set that aside, and that will also help you look better in front of the eyes of the judge, who sees that you're just trying to be civil and this is a monetary dispute. This isn't about personal attacks or anything like that. So get off that kind of high horse, if you will. And I'm not saying this to try and be judgmental. I totally understand. I've personally been involved in small claims court dispute. Well, one small claims court dispute, I should say, hopefully the last, many, many, many years ago. And it was not fun, and it's emotionally charged, and I totally understand that, but it's very effective and very advisable to sort of let that go as best as you can while you're in that courtroom and asking questions of the defendant. Put that to the side, and you can start off very civilly. Good morning, Mr. Smith. Good morning. Mr. Smith may or may not say that back. In fact, if Mr. Smith is belligerent still and he's highly emotional, all the more better for you. Okay, so you start off with that warm-up. It ties in with the idea that it's not the movies. You're going to be civil and courteous. You don't have to yell and shout to make your points. You're trying to make your points in as civilized a way as you can. Sometimes things can get heated, but by and large, as a self-represented person, you're not going to score any points by yelling and screaming. You're going to do a much better job of impressing upon the judge by doing things civilly and calmly. If you ever watch debates on YouTube, for example, in my opinion, most of the time, those who are debating calmly and civilly come across much more impressionable than the ones who are yelling and screaming and carrying on. And the same thing for when you're in the courtroom, all the more better if you can do this in a very civil way, no matter what your personal feelings are for the defendant. That leads me to key number 3, which states leading questions. So what do I mean by that? Well, if you remember from the last video, I talked about the idea of the questions that you're asking for your witnesses should be open-ended. What happened? When? Why? How? Etc. Very open-ended, which comes across as more credible because you're not leading the witness to the answers that you want. If a judge sees that you're leading the witness on, then the judge may take what the witness is saying with a grain of salt, because the judge can see that, hey, this person's kind of taking the witness to where they want to go. Contrast that with cross-examination, where not only can you do leading questions, and again, even in small claims courts, even for your own witness, you can often get away with leading questions depending on the courtroom, okay? But generally speaking, you should avoid leading questions in your own examination questions for your own witnesses. But when it comes to a defendant, the opposing party, not only can you do leading questions, it's advisable, it's recommended to do leading questions. That's the best way to elicit the responses or non-responses, as you'll soon see, that you want from the defendant. So leading questions are excellent for cross-examination, and that's what you should be doing. A lot of people make that mistake and think, oh, I can't ask leading questions in court. No, it's not true. You cannot, again, in most courts, ask leading questions of your own witnesses, but of the other witnesses, you should ask leading questions. What does a leading question mean, in case you didn't see the previous video? So that would be a question like, isn't it true that on October 1st, 2023, we entered into a contract? That's a leading question because you're leading the witness to answer yes or no. You really want to get those yes or no answers, by the way. Those are great answers for you, because if you're framing your question in the right way, a yes or no answer is the best way to get that evidence in front of the judge. It's very simple. It makes the point easily. If you watch trials, if any of you ever watch court TV, you'll notice after you watch this video that when a lawyer is cross-examining the other witness, that lawyer is by and large going to use yes or no questions. Some lawyers have different strategies and they may come about it in different ways, but for the most part, that's what lawyers are trained to do, and that's what good litigators being lawyers that are in the courtroom representing clients, they ask leading questions trying to elicit the yes or no answer. If you don't get the yes or no and the defendant is being belligerent about things, keep using the word belligerent, don't worry about it. Like I said, you don't always need the defendant to say exactly what you want to say. A lot of times the point is made, even if the defendant's response isn't precisely a yes or no. In fact, a lot of times the defendant will look like they're trying to get around what the answer is, because they know that answering yes or no will be bad for them. And a judge will often pick up on that. So don't be overly pedantic about worrying about whether you get that yes or no, but that's what you're aiming for. You're striving to try and get that yes or no. And that's by doing leading questions. Isn't it true that? And you're going to see as I go through a sample here, an illustration very shortly. And finally, the fourth key I have written down, as I keep alluding to, I've written down as statement question. Now, what's an example of this? What does that mean, statement question? I just made up that term as I was preparing for this video. A statement question means something like this. You would say to the witness, the reason why you haven't presented that is because you don't have that evidence. Like that. You've kind of made a statement. You could argue that that's a question. You could end it with a question by saying, you don't have that evidence, do you? But you can also say the reason is because you don't have that evidence. Like that. It's kind of a statement / question. Another example would be, I put it to you, sir, that you never did take a photograph, right? Something like that. Again, you can kind of phrase it in a way that can end as a yes or no question. But especially, as I was saying before, if you see that the defendant is not giving you those yes or no's, you can sort of make those statement questions. I put it to you that you don't have evidence for that. And it doesn't matter what the defendant says, because you've kind of made the statement for the defendant by asking, quote unquote, that statement question. Okay, as I go through this, hopefully this will become clear as I go through a little illustration. So I mentioned the illustration case of what's happening between you being John the landscaper and Jim Smith not paying you. And now let's go through all of the defendant's testimony to see how you would ask an effective cross-examination. Of course, this is a very simplistic example. Trials could take a lot of twists and turns, but by getting basics and fundamentals and not getting too bogged down with too much, I'm not trying to turn you into lawyers overnight. That's the best way that you can kind of adapt on your feet as well for situations that arise. Okay, so the first thing that Jim Smith said in his defense when he was testifying is that he never agreed to the price. He never agreed to the $10,000 that you, John, are claiming in the lawsuit. So what would be an effective cross-examination? So let's say Jim had said, yeah, the contract says $5,000. So this harkens back, by the way, to when I talked about preparing an evidence brief, because you have to be very organized. You want to know in advance sort of the types of questions you may be asking. It's hard to be precise because, as I said before, when you want to pay attention to the defendant, you have to be listening to see if the defendant is kind of going along with what you've expected as you prepared for trial, and the defendant may take some different twists and turns. But by and large, you want to have a sense of the types of questions you want to ask the defendant, cross-referenced with the evidence that you're going to use to refute the defendant. And that evidence is going to be contained in that evidence brief that I recommended that you prepare in an earlier video. So you've got your evidence brief. You have here the defendant claiming that he never agreed to that price, and he's relying on the contract. The contract only says $5,000. So why on earth should you, John, the plaintiff, be asking for $10,000? So you're armed with emails that are contained in the evidence brief. And so you ask the judge permission to approach the defendant. It doesn't have to be that formal necessarily in small claims court, depends on the small claims court, but you show the defendant the email and you say to the defendant, isn't it true, Mr. Smith, that we actually did discuss increasing the price of the contract? No, we didn't. Well, Mr. Smith, I'm showing you an email contained at tab D of this evidence brief. Can you please read this? And then Jim reads an email where it says, John, I need you to use better materials. And then he reads the reply from you, John, to Jim. Sure, Jim, I can do that, but that's going to cost you an extra $5,000. And then Jim says back, that's fine, just do it. Okay, so there's an example of where Jim had claimed that the contract says that it's only $5,000 and he wants to rely on that. However, you, John, were able to cross-examine Jim by referring to the evidence, referring to emails, showing that indeed there was an agreement subsequent to the contract that stated that you would agree to the change orders for $10,000. And notice how I asked the questions. I'm going to keep repeating this so it gets, into your consciousness deep in there. Notice how he said, isn't it true that we had an email exchange about this? And again, even if Jim says, no, we didn't, even better, because then you show him, well, I'm showing you this document. What would you entitle this document? Well, it looks like an email. And what is this? And isn't it true that these emails show that you had asked me for change orders of $5,000? No, it's not. Oh, really? Can you please read the email? So you get it? So not every question has to be a yes or no, obviously, but you're kind of peppering yes or no questions wherever you can to lead that witness along to where you want to take him to. Okay. And again, very simplistic examples. I also want to point out that law is so complex. There can be a concept here. Don't take this too much at face value in terms of the actual sample, because a lot of contracts have what's known as an entire agreement clause. It may be called something different around the world, but the entire agreement clause oftentimes will say, even if there's an outside agreement, it will not count. Only what's written in the contract will count. Okay, which is very important for plaintiffs to be aware of. I'm going to do a video about preparing a good contract for yourself to help avoid small claims court, or to help you in the event you do have to go to small claims court. Okay, that's beyond the subject of this video, but just bear that in mind. For any of you that may be wondering, don't they have those clauses in contracts? Like, how could an email trump a contract? So two things I would say is, one, let's go in this sample example where there wasn't such a clause in the contract. It was a very basic contract. And two, oftentimes small claims court is known as what's a court of equity, a court of fairness. And a lot of times emails can be used as evidence, particularly in a people's court like the small claims court. Okay, but that's sort of the nuts and bolts that you don't have to worry about. The point I'm making here is how to ask the witness questions that will get him to admit, or at least will show the judge, that there were emails that show the actual amount of the contract. Despite Jim claiming it was only $5,000, the emails show that they actually agreed on $10,000. The next part of Jim's testimony was that the materials were bad. Okay, so let's say that the types of materials that you, John, had used were actually agreed to in the contract. So you can say something like, so I'm pointing here to contract as an example of where you can cross-reference. So you can say something like, Mr. Smith, you said that the materials that I used were not what you had wanted. Is that correct? Yes, it is. Mr. Smith, isn't it true that in the contract, we had agreed to these materials? No, what are you talking about? Well, Mr. Smith, I'm showing you the contract in which it states that we're going to use materials A, B, C, D, and E. Do you see that here? Well, yes, I see that, but blah, 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 blah. And isn't it true that it's written here that we're going to use this specific materials? Yes or no? Well, yes, but blah, 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 blah. And isn't it true that you signed this contract and agreed to these materials? Well, et cetera, et cetera. So you see, again, you're asking the isn't it true questions, yes or no questions. And regardless of what the defendant says, it really doesn't matter as long as you make the point for the judge. Now, obviously, if the defendant says something that kind of takes away your argument, you have to be quick on your feet to the best that you can to pivot from that and be ready. And that's why it's so crucial to know all your evidence and all the defendant's evidence inside and out. It's very crucial. I'm just keeping things very simplistic here to show you how to ask those questions, but obviously you have to be prepared to pivot where the defendant takes you in a different direction. But overall, if the defendant is just, I think the word is obfuscating and just not answering your question, that doesn't matter. You're still making the point for the judge, as I talked about with the statement questions, okay? You can even say something like, Mr. Smith, you're refusing to say yes or no. I put it to you that we did agree on these materials. And then you can move on. Mr. Smith doesn't have to even say anything. The defendant doesn't have to say anything. You move on. You've made that statement so the judge knows what you were getting at, and the judge will decide what they think of what you just had said to Mr. Smith. Okay? Something else, by the way, I put down text messages too, just as another example. I've made the point already. You can point Mr. Smith to Mr. Smith being the defendant. Notice how I'm being civil. I'm calling him Mr. You could point him to text messages as well. The same sort of idea. Isn't it true, Mr. Smith, that we also had a text message exchange about this? You know, no, it's not. Well, Mr. Smith, I am showing you this document at tab E. And would you call this a text message? Yes or no? Well, it is. Okay. And Mr. Smith, can you read this text message? Et cetera, et cetera. You get the point. Again, I told you I'm going to be repeating this, knocking this into your head, so to speak, so that you really get the point. It is a bit repetitive, but I just want to show you how this will work. Trials are repetitive. Cross-examining is repetitive because you want to elicit evidence and you have to do it methodically and ask the same types of yes or no leading questions to get out all the evidence that you need to refute the defendant. So we refuted the fact that the price was actually $10,000, not $5,000, as Smith claims. We refuted the fact that you used bad materials or materials that Smith didn't want because actually it was in the contract and it was agreed by text messages. And then we have Smith saying that the work was shoddy. So once again, you can say to Mr. Smith, okay, the work was shoddy, isn't it true, Mr. Smith, that I have a report stating that the work I did was excellent? So just to remind you, I talked about this in an earlier video. I don't think I mentioned it here. In this case, you, John, the plaintiff, you were wise enough to get Sally Jones, whatever name I used before, as an expert engineer who put out a report and who's also there to testify that the work was excellent and workmanlike. And that report is at tab E, let's say, of the evidence brief. So now back to cross-examination. Isn't it true, Mr. Smith, that there's a engineer's report of Sally Jones at tab E stating that the work was great? Well, I don't care what the report says. I didn't see any such report. Oh, you didn't? So, Mr. Smith, can you turn to tab E, please? He turns to tab E, and if he refuses, the judge will make him. And Mr. Smith, would you state that this is a report authored by Sally Jones? Well, I see her name there. And can you read from line such and such where Sally Smith says that the work that John I did was excellent and up to par and was worthy of being paid for the work that he provided? Can you read that, please? Etc., etc. Okay, you get the idea. And you can also challenge Mr. Smith, for example, if he doesn't have his own expert report. Mr. Smith, isn't it true that you've got nobody to corroborate your claims that the work was shoddy, correct? Well, I know, and Mr. Smith may say something back like, well, I know I'm a homeowner, I've had other renovators before, and I know what good work looks like. Oh, really, Mr. Smith, isn't it true that none of the renovators that you're claiming that did this work for you are here to testify? Isn't that correct? Well, what do you want from me? That was, years ago. Well, Mr. Smith, you've made an allegation that the work was unworkmanlike. I've got an expert saying that it was great work, and you have nobody other than yourself to claim it was bad work. Isn't that true? You get it? So you're continuing to weave that web by asking these yes or no questions. And finally, because I think I've made my point, but just to sum up, I addressed all the points that I raised at the beginning of the video that Mr. Smith said in his testimony. He said he had to redo the work. So once again, you can attack Mr. Smith with photographs. Mr. Smith, and here's an example. If you know that no photographs have been presented by the defendant, then you can ask an open-ended question. Mr. Smith, do you have any photographs here to document your claims that the work was shoddy? No, I don't. It's kind of a yes or no, because he's going to say no, or he can say anything. He may say like, I didn't have to take any photographs. I know what I saw. But you've made the point that he doesn't have photographs. And Mr. Smith, I've already gone through photographs that we all saw at tab F. Isn't that correct? Yeah, well, you could doctor those photographs. Mr. Smith, have you brought any experts to indicate that those photographs were doctored? Blah, 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 blah. So Mr. Smith will go on, but you see how you're weaving that web to attack not only his evidence, but non-evidence, evidence that Mr. Smith has not provided. And the same thing, you ask Mr. Smith, isn't it true that you have no witnesses to corroborate what your claims are regarding shoddy work? Well, what do I need witnesses for? I'm a homeowner, blah, blah, blah. I put it to you, Mr. Smith, and here's an example of a statement question. I put it to you, Mr. Smith, that you didn't bring any witnesses about the work being shoddy because the work was not shoddy. And again, that makes the point. You let that sit. Don't worry about what Mr. Smith says back. Just let that sit. Let that sizzle so that the judge hears that. Okay? And then finally, I've written down here proof of payment as well, so you can attack Mr. Smith on showing that he had to redo the work, because Mr. Smith is claiming he had to redo the work. And assuming for our illustration cases that he did not bring any other person who did landscaping work. I mentioned renovation before, but you get my point. He didn't bring anybody else to testify on his behalf. You can put it to him, Mr. Smith, you said that you had to redo the work. Is that correct? Yes, it is. But isn't it true, Mr. Smith, you haven't presented to this court any receipts for having to redo that work with somebody else. Isn't that correct? No, there were no receipts. It was a cash deal. I put it to you, Mr. Smith, that you never really did redo that work, did you, Mr. Smith? Oh, no, I did. And in fact, Mr. Smith, I put it to you that you're claiming that it was a cash deal because you never really paid anybody to do any of that work. Isn't that true, Mr. Smith? You got it? Now, one thing I think that really, gives you a sense of how to ask those cross-examination questions in a leading manner. One thing I do want to make you aware of as well, I mean, there's so many things I can make you aware of, but I don't want to bog you down too much. I'll just try and break it to future videos, but I do want to make you aware that it is a bit precarious only because, as I mentioned in my earliest video, there is, in most small claims courts worldwide, the opportunity for a party to ask for an adjournment. Okay, so let's say you attack a defendant in a certain line of questioning by claiming that there's no photographs. So Smith may say back, actually, there are photographs. And then the judge may intervene. Well, where are those photographs? Well, I didn't know I had to bring them, Your Honor. And so there may be an adjournment where the defendant and you have to come back another day and resume the trial. And in that case, there are photographs. So in your line of questioning, you went with the assumption that there's no photographs, and all of a sudden, Mr. Smith brings photographs. I wouldn't worry about that too much because judges are aware that you can only work with the evidence that you have. So even though you said something and you made a statement regarding not being photographs, and it turns out that there are, that doesn't mean that you've been disproven or anything like that. A judge realizes that you could not have known about that, and it was fair for you to take that line of questioning. But still, you should always be mindful of what the evidence is, what the defendant has presented, and what the defendant has said. Because if you do go down the wrong path where you make a statement or a suggestion or a statement question that does not align with the evidence that the defendant has actually shown, you can really do damage to you. So all the more reason that you have to be very aware not only of your own case, but also the defendant's case, what the defendant has said in the past, what the defendant has said in court filings, if there are any, and what the defendant has said under oath in his testimony. So just to review very quickly, I talked about the 4 keys to a killer cross-examination. Key number 1 is to start the defendant slowly and easily with some warm-up questions to get him used to answering your questions. Key number 2 is to not think that you're in the movies. Don't get overly emotional. Don't attack personally the defendant. Be polite and civil. Lay your ego on the side, so to speak. Lay your emotions on the side. Let them go for these purposes and just really focus on what it is that you have to disprove. Put everything else on the side. Key number 3 is to ask leading questions. You should be asking leading questions. Try and get those yes or no answers. But if you don't necessarily get those yes or no answers, don't worry, because the judges could really understand, in most cases, what you're getting at, even if you don't get the answer that you had wanted. And finally, statement questions can be a very effective tool as well, especially if the defendant's not giving you those yes or no's. Just putting it out there as a kind of statement, quasi-question, can be a very effective tool for making the point for the judge in any event. Okay, so I hope you found that video helpful. I do understand that that was a lot. It's a lot to absorb. One of the beauties of YouTube is that you can pause videos, you can rewatch them, and you can also comment. And I definitely suggest, definitely for you subscribers, in this channel's infancy, you have a chance to leave comments, maybe dealing with specifics of your case. I don't give specific legal advice, but if I see there something that I feel can benefit the audience at large, then if you have a question or a comment, that may just be something that I address. As the channel continues to grow and there are more and more subscribers and more comments, I don't mean to be presumptuous, but that's usually how it goes. And I have faith that my channel will be helpful to people and continue to grow. It will be much harder for me to do that. If not, well, I don't like to use the word impossible, but highly unlikely. But right now, you have subscribed, you have a chance to do that. And general feedback is welcome as well, even if it's not a question. Comments are definitely welcome. Please do share this video with anybody who you think can benefit from it. Of course, don't forget to like the video, hit the subscribe button if you're not currently a subscriber, and the notification bell so you don't miss a future video. I really appreciate you coming to my channel and subscribing. And until next time, I'm looking forward to seeing you at the next video. Hey, thanks for watching. If you found that video helpful for winning your small claims court lawsuit, then you're not going to want to miss a future video. Hit the like button, the subscribe button, and the notification bell. It takes a second so that you don't miss a future video to help you win your small claims court lawsuit.